The latest movement inside the Supreme Court has created a wave of attention across the country, especially among gun owners, legal analysts, and anyone following the ongoing fight surrounding the National Firearms Act. A major petition involving short-barreled rifles and the broader NFA framework has been pushed forward for consideration, and the implications of this single step could reach far beyond the parties involved. Even though the Supreme Court has not agreed to hear the case yet, the simple fact that this issue is now on the court's radar has intensified the national conversation about where the Second Amendment stands after landmark decisions like Bruin. What we are witnessing is not a final ruling, not a direct decision on the constitutionality of short-barreled rifle regulations, but the opening stages of a process that could reshape federal gun policy depending on what the court chooses to do next. This development centers on a case known as U.S. v. Rush, where the defendant, Mr. Rush, challenges the NFA's restrictions on short-barreled rifles, arguing that the registration and taxation requirements violate the Second Amendment. His fight began after he was charged with possessing an unregistered SBR under Section 5861D, and throughout the course of his legal battle, he has consistently argued that these restrictions infringe on his constitutional rights. His argument leans heavily on the Supreme Court's ruling in Bruin, which clarified that modern gun laws must align with the nation's historical tradition of firearm regulation. According to his petition, the NFA's SBR restrictions do not align with that tradition, and therefore they should be struck down as unconstitutional. The lower courts did not agree with him. The district court ruled that short-barreled rifles fit into the category of dangerous and unusual weapons, a classification that traditionally falls outside of Second Amendment protection. That court's position was largely upheld by the Seventh Circuit Court of Appeals, which relied on an older Supreme Court precedent from the case of U.S. v. Miller. In Miller, the court suggested that weapons not shown to be commonly used by law-abiding citizens for lawful purposes might not fall under the Second Amendment safeguard. Because of that precedent, the Seventh Circuit viewed the NFA's SBR restrictions as historically consistent with firearm regulation, but the landscape has changed dramatically since Miller was decided in 1939, and the Bruin ruling further altered that terrain by demanding that courts reevaluate gun restrictions under a historical framework rather than a means-end balancing test. The petitioner argues that the lower courts twisted or misunderstood Bruin, applying it incorrectly and relying too much on post-founding era laws that do not accurately reflect the historical context the Supreme Court outlined. According to his filing, the idea that common arms such as short-barreled rifles fall outside Second Amendment protection is not supported by historical evidence and represents a major misinterpretation of the court's guidance. The Supreme Court responded by ordering the Trump Department of Justice to file a response, something the DOJ initially waived. When that response finally arrived, it surprised many in the gun rights community. Instead of supporting the petitioner's position or even adopting a neutral tone, the Trump DOJ argued strongly that the court should not take up the case. They maintained that the NFA remains constitutional and that short-barreled rifles can still be regulated under certain circumstances, even within the boundaries of the Second Amendment. Their position echoes the lower court's reasoning that some gun regulations can coexist with constitutional protections if historical analogs exist. Even more interesting, the Trump DOJ stated that this particular case is not the appropriate vehicle for addressing the broader question of whether certain firearms, such as SBRs or AR-15-style rifles, are protected arms. They recommended that if the Supreme Court wants to address the broader arms ban issue, a topic that has generated heated debates in states like California, New York, and New Jersey, it should do so through a different case, preferably one involving statewide bans on commonly owned rifles rather than NFA-related issues. In other words, they suggested that the court skip this petition but take up another challenge that more directly confronts bans on modern rifles. This recommendation alone has created controversy, because it acknowledges that the court may need to resolve some of these long-standing legal questions, yet it argues that this particular challenge is not the right moment to do so. This puts the Supreme Court in a position where they must decide whether they want to silence the confusion surrounding the Second Amendment by taking up a broad arms ban case, or whether they will continue allowing lower courts to interpret Bruin as they see fit, even when those interpretations differ significantly across jurisdictions. The case is currently scheduled for conference on December 12th, where the Supreme Court justices will meet behind closed doors to decide whether they want to hear it. Importantly, this case is not going alone. Another NFA-related case, known as Robinson, is also being brought into the same conference. That means the court will consider two separate challenges related to short-barreled rifles and NFA restrictions at the same time. While both petitions request the court to step in and correct what the petitioners describe as inconsistent or misguided interpretations of the Second Amendment, the general expectation among analysts is that the court may deny both petitions, but a denial does not necessarily mean the court endorses the current state of the law. Often, a denial simply means the court does not view the case as the right vehicle for resolving the legal questions presented. And sometimes, when the court denies a case, one or more justices issue a separate statement explaining why the issue still requires clarity. That kind of statement can be incredibly influential, because even without hearing a case, the justice can signal to lower courts how they should interpret or apply the Second Amendment moving forward. Many watchers believe that if the court denies review in the Rush or Robinson cases, there is still a chance that someone like Justice Clarence Thomas may issue a dissent or a statement from denial emphasizing the importance of resolving the broader arms ban questions in the future. In his reply to the DOJ, Mr. Rush argued forcefully that the lower courts have taken a dangerously wrong turn in their interpretation of Bruin. He stated that the Seventh Circuit essentially concluded that the Second Amendment does not even apply to SBRs, which he believes contradicts the Supreme Court's explicit guidance that the Second Amendment covers all bearable arms. He pointed out that short-barreled rifles are common firearms, and that the government's justification for regulating them relies on a patchwork of laws enacted decades after the founding era, which does not satisfy the Bruin test. His position is that the NFA restrictions are not historically supported, and therefore they should fall outside the realm of constitutional firearm regulation. In response, the government did not fully defend the Seventh Circuit's reasoning that SBRs are not arms protected by the plain text of the Second Amendment. Instead, they leaned on the idea that the NFA has valid applications and that because of those valid applications, a facial challenge, one that argues the law is unconstitutional in every circumstance, should fail. That means the government is not arguing that the NFA is perfect or that every part of it is unquestionably justified. Rather, they argue that as long as any part of it has historical validity, then the court should uphold it against a broad challenge. This legal back and forth reflects a much larger debate taking place across the country. States like California, New York, Illinois, Oregon, New Jersey, and others continue to pass aggressive gun restrictions that include bans on common rifles, magazine capacity limits, and other regulations that directly conflict with the guidance of Bruin. Gun rights advocates argue that these states are deliberately ignoring the Supreme Court's instructions. Meanwhile, lower courts are split on how to apply the Bruin test. Some have struck down modern gun restrictions using the historical tradition requirement, while others have upheld restrictions by expanding the pool of historical laws or interpreting them differently. This inconsistency is precisely what has led many to hope that the Supreme Court will step in soon. The Rush and Robinson cases provide the court with an opportunity to address these inconsistencies, even if they do not end up hearing the cases. If the court were to grant review, it could significantly reshape the landscape of federal gun regulation, particularly as it relates to NFA-regulated firearms. If the court denies review but issues a statement, that statement could provide guidance that influences dozens of ongoing cases across the nation. The ripple effect could be massive, affecting not just SBR-related cases but also broader challenges involving AR-15 bans, magazine restrictions, and other modern arms regulations. While we wait for the December conference, the legal world is paying close attention to what comes next. A denial without comment would likely leave things where they are, with conflicting interpretations across the circuits. A denial with comment will provide new direction, possibly pushing lower courts to apply Bruin more consistently and more strictly. And a grant of review would set the stage for one of the most significant Second Amendment cases since Heller and Bruin, potentially reshaping the NFA's authority and influencing gun regulations nationwide. As we move closer to the court's conference date, this case continues to highlight how much uncertainty exists in Second Amendment law right now. The Supreme Court's next move, whether to hear the case, issue a statement, or quietly step aside, could shape the nation's approach to firearm regulation for years. And although the outcome is far from certain, the fact that these cases are reaching the doorstep of the Supreme Court is a major moment for the ongoing debate about Americans' rights, historical context, and the limits of federal firearm authority.